You are watching PR English Shorthand Dictations YouTube channel.
This is English Shorthand Dictation number 296 and the dictation speed is 100 words per minute. Ready? Start. It is my immense pleasure and privilege for being with you on the occasion of Lawyers' Meet organized by the Bar Council of India. I extend my greetings and good wishes to all members and officers of the Bar Council of India present here today. You are all key players in our ongoing determination to provide legal aid and access to justice to all our citizens. Access to justice should not be understood to be reaching out in geographical terms. Access to justice means fair adjudication of disputes arising in the society, both through formal and alternate methods of justice delivery. On one hand, there are formal systems of justice like courts and tribunals, which are available to a person when he is in need of fair resolution to a dispute or an issue. On the other hand, there are traditional but fair systems of adjudication, which can be peer groups, village elders, village panchayats, or any other form of alternative dispute resolution, including mediation, conciliation, and arbitration. I am very clear in my mind that the formal systems of justice delivery consisting of courts, judges, and lawyers will never be able to meet growing demands of justice delivery in our country, which is populated by more than 1 billion people. What is important is creating a society which has less of disputes, a society which can resolve disputes through its own local mechanisms in a fair manner. If not possible, we can at least provide alternative dispute resolution mechanisms in a formal or informal manner, which costs less and provides quick resolution of disputes. The point which I would like to make very strongly is that by talking about access to justice, if we mean that we are going to establish a court and provide a magistrate in each and every village, I think it is a wrong idea and not practically achievable, and it is not affordable also. Access to justice has another angle of affordability. One may have plenty of something around him which he needs badly, but it is of no use if it is not affordable for him. This is the story of access to justice in our country, as large sections of our population are not economically well off. Their capacity to access the justice delivery system becomes limited. As a result, though a citizen of India is free to engage the best lawyer in the country to secure a favorable but a genuine result, he may not be able to achieve that due to the cost factor. This is not a hypothetical situation, but a finding brought out by a study conducted by National Law University students, which brings out that 75% of those given harsh punishment like death penalty belong to economically and socially backward and weaker sections of society. Though our justice delivery system, in principle, is not a class based system, the data brought out by the study hits very harshly at our face that in practice, due to various factors, especially the cost factor, our system may have become a class based one. Now it is our duty to stand up and correct this anomaly, failing which it may result in miscarriage of justice. One of the fundamental factors brought out by this study is that of affordability. We know that engaging of best lawyer either at high court level or at the Supreme Court level is a very costly proposition even for an upper middle class person. If that is the case, what will be the fate of 60% of lower middle class and poorer sections of society? I am of the opinion that at the subordinate courts also, if the system is not affordable for 60 to 70% of the population, we cannot say that we have achieved access to justice for all. Now, my brothers and sisters, tell me where we stand and where we are headed to. I would also like to stress one thing very clearly, that this issue of affordability can never be tackled by the government, as this responsibility primarily depends upon all of you. If, as a responsible citizen of this country, you want to ensure the access to justice to all our fellow citizens, you all need to think about this cost factor and how to do something about it. There are three ways by which we can reduce the high level of litigation. These three ways are avoiding litigation, adopting alternate dispute resolution mechanism, and adjudicating quickly. Litigation can be avoided if all of you advise the clients to avoid litigation, resulting to arbitration as an alternative dispute resolution mechanism needs to be encouraged at every level. The alternative dispute resolution mechanisms are not only quicker in disposing of the disputes but also bring down the pendency in the courts as well as the cost of litigation. If the bar and its members advise the clients to opt for alternative dispute resolution mechanisms, I am sure in the days to come this will become popular. There are about 2.6 crore cases pending in various courts in our country. We are struggling to draw up plan to clear the pendency. The Code of Civil Procedure was amended with a single point agenda to speed up disposal of cases. Have we achieved it? If we have not achieved it, have we thought about why we have not? Where have we gone wrong? As the intention behind the amendment is noble and very close to the hearts of people, we need to reflect on these issues and come up with solutions for the obstacles in speeding up the disposal. Failure to achieve the desired objective is because the stakeholders have not owned it up. We have envisaged a National Litigation Policy 2015 to contain frivolous or unwarranted litigation by and against the government. This will address the problem of increasing load on the judicial system. The policy outlines mechanism to reduce filing of cases by or against the government.